Hello, everyone, and welcome to our webinar on Ireland's climate justice obligations, legal, scientific and policy. My name is Rose Wall and I'm the CEO of Community Law Mediation, and I'm delighted to be joined today by Professor Kevin Anderson, Dr. Andrew Jackson and Oisin Coughlin, who have generously offered their expert scientific, legal and policy insights for today's discussion. Before I hand over to our speakers, I want to say a little about who we are and the work we're doing in this area. Community Law Mediation is a community-based independent law centre and charity providing free legal services to underserved communities since 1975. Our work has always focused on issues which disproportionately impact those experiencing disadvantaged, inequality and poverty, including housing, homelessness, social welfare, discrimination, accessing health and education services, and more recently, environmental justice. In 2021, we set up Ireland's first and only Centre for Environmental Justice in recognition of the fact that underserved communities are more vulnerable to the effects of climate change, pollution, energy poverty and other environmental harms, but also in recognition of the potential for climate action to be a justice rather than a threat multiplier, whether that is through warmer homes, lower energy costs, decreased air and water pollution, access to green space and improved public transport infrastructure. Our centre aims to empower and equip individuals, community groups and organisations to challenge environmental injustice using the law, and this includes representing clients in climate litigation cases. Two of those cases are relevant for mention today. The first is a case we are taking on behalf of Friends of the Irish Environment, and which is listed for hearing in the High Court next Tuesday. This case will argue that the government has failed to demonstrate with sufficient detail that the Climate Action Plan 2023 and its annex of actions will reduce greenhouse gas emissions in line with Ireland's legally binding carbon budgets, and that this constitutes a breach of the government's legal obligations under the Climate Act. In the second case, in which leave was granted last September, CLM is the applicant and is joined by a grandfather, a youth climate activist and a child. In that case, we are seeking a declaration from the court that the Climate Action Plan 2024 is invalid as it breaches the Climate Act, but also that it violates the fundamental rights of the three individual applicants, marginalised groups that CLM works with, and future generations as protected by our Constitution, the European Convention on Human Rights, and the European Charter of Fundamental Rights. Andrew Jackson is going to speak a little bit more about climate litigation, but from CLM's perspective, in taking cases in this area, we're seeking to safeguard the rights of those most impacted by climate change, but with the least opportunity to protect or vindicate their rights. Climate action must match ambition. Through these cases and other cases, we hope that Ireland's climate policies will be revised to set out a sufficiently clear roadmap for effective climate action in line with Ireland's legal obligations, to ensure that a just transition can be planned and delivered, and to protect the rights of present and future generations. And now for the presentations. We're going to hear from three very distinguished speakers, and I'm very grateful for their input today. There will also be a short period of time for Q&A at the end, so if you do have any questions, please just put them in the Q&A box. Our first speaker is Professor Kevin Anderson. Kevin is a climate scientist and Professor of Energy and Climate Change at the Universities of Manchester, Uppsala in Sweden, and Bergen in Norway. Formerly Director of the Tyndall Centre, Kevin continues to engage widely across all tiers of government on issues ranging from shale gas, aviation and shipping, to the role of climate modelling, carbon budgets, and negative emissions technologies. Kevin's analysis previously contributed to the framing of the UK's Climate Change Act and the development of national carbon budgets. Kevin is going to speak now about the gap between where we are and where we need to be to remain within 1.5 degrees. Thank you, Kevin.
Thank you. Let me just share the screen. As typical academic, we can't survive without our PowerPoints. So hopefully, can you do this work properly? Can you see that okay? Is that clear to you?
Yes, that's fine.
Good. Okay. So I'm going to look at just thinking about Ireland in relation to 1.5 degrees centigrade. And I've also said 2 degrees centigrade here, and it'll become clear why I'm talking about that as well. For those that have social media accounts, I use Blue Sky and less now Twitter, but I have that, but also a website where I put a lot of my work and other blogs and posts. So I think it's important to start off by remember what our key concern is. This is obvious, perhaps, hopefully to most of us here, but it's not temperature. Our key concern are impacts, whether that's flooding, droughts, whatever it might be, fires, mass migration, military tension that comes out of these sorts of things. So we have to remind ourselves it is impacts, not temperature, that really matters. And even when it comes to impacts, it's actually the rate of change of impacts that matters. If the impacts occur over 1,000 years, then probably most of us can deal with that, human systems and even ecosystems to some degree. But if they occur over 5 years, that can be catastrophic. So it's the rate of change of impacts that's really important. And then can our systems adapt? Can ecosystems adapt? Of course, we're reliant on them and we're part of them, pollinating insects and so forth. And an important question, well, a point in all this is, who is the we that makes this decision? The we part is massively important and is hugely biased, as it's pretty evident, I think, to the global north and even the wealthy within the global north. So what have we committed to deliver? So if we go back to UNFCCC, and I think this is important, I'll come back to this later. This is what we committed to. Regardless of what our national policies may be, ultimately we committed to avoid dangerous anthropogenic interference to the climate system. Put simply, cut emissions so to avoid dangerous climate change. But we also, in Article 3 and partly Stroke 4 of the UNFCCC, we agreed to do so in a line with common but differentiated responsibilities. In other words, cut emissions fairly, with developed nations taking the lead. So every COP that we have it builds on these two really key articles. And I think we have to remind ourselves that when we think about temperature, actually it's the impacts and the articles here that relate to those that really are key. It was 23 years before we then defined what is actually dangerous, which is obviously a political decision, not a scientific decision. And that is to hold to well below 2 and pursue 1.5, guided by science and on the basis of equity. The problem with that sort of language is it's not very helpful for us as sort of quantitative academics, because it's adjectives. So how do we convert adjectives into probabilities? Well, I think it's fairly common now to say that well below 2 degrees centigrade in the language of the IPCC is a high chance of not exceeding 2, at least 83%. That's the highest probability that the IPCC provide in their headline carbon budgets. And for the secondary commitment for 1.5, commonly it's seen as a 50-50 chance of not exceeding 1.5. If you're on the sharp end of the impacts, that's nowhere near good enough. But at the sort of global level, that's been taken on board. And that's typical within the EU, for instance, to think of a 50-50 chance, or indeed here in the UK. But since Paris, there's a lot of work that has demonstrated that the impacts of 1.5 are much worse than we initially thought they would be. So between 1.5 and 2, these are not just very small differences in impacts, there are very large differences in impacts between the two. And I think it's, when we go back to the UNFCCC, this idea of dangerous anthropogenic interference with the climate system really tells us that the impacts for 1.5 were what we were thinking nearer for 2. So really 1.5 is the new version of what 2 was. So we should be having our primary commitment should be around 1.5, not 2 degrees centigrade. I say that, so we've recognized that from the science, but when you look at where we are, I mean, it becomes almost impossible to deliver on 1.5, and I'll try and demonstrate that in a minute. But it's also worth noting that if you do finally get your Taoiseach, and if it does end up being Michael Martin, then he has said that Ireland is ready to play its part in delivering on 1.5. Now, every country has some polished rhetoric that says the same sort of thing, or that many countries do, but in reality, when you unpick it, it's far from that. So what does the science tell us about the timeline for 1.5? Well, here we have the IPCC carbon budgets from the last IPCC report. And what we get is for tables like this, which pack full of numbers and lots of plots and so forth. But basically, if you want to stay below 1.5 or 2 degrees centigrade, then from 2020, and for different probabilities, it gives you a whole range of carbon budgets, which are the total amount of carbon dioxide that we can emit, which broadly means how many tons of fossil fuels can we consume. That's basically what those numbers tell us. And if we look at our commitments under Paris, then for 1.5, according to Paris, according to the IPCC at the time, then we have about 500 billion tons of CO2 that we can emit. And if you go for 2 degrees centigrade, it's a large number, 900 billion tons. This doesn't mean much to most people, but I'll come back to this in a minute, these actual numbers. Because I think we have to also bear in mind that since IPCC R6, a lot has happened. So we've pumped into the atmosphere an extra 200 billion tons of carbon dioxide just in the last few years. Most of the research that fed into AR6 from the IPCC, Assessment Report 6, was based on research that was probably prior to 2019 or before. So there've been many improvements in our understanding. And I think key amongst these, at least in my view, firstly, the aerosol issue, that as we clean up fossil fuels, we get extra warming because we're removing cooling aerosols. There's improved understanding of the climate sensitivities, a better grasp of the non-CO2 emissions, of the warming that we still get locked in even when we reach zero emissions. And then there's a whole suite of sort of feedback issues as well, some of which are included, some of which aren't. So there's a whole set of key issues here. Which budgets we choose is ultimately a judgment call. And I think we have to be quite cognizant of a number of factors here. Firstly, are the budgets for not exceeding or staying below these temperature thresholds? Or some papers, you'll be very careful when you read the papers, they're not about staying below or not exceeding. They're about passing through those temperatures on the way to higher temperatures. So there can be quite significant overshoot scenarios. So those budgets, I would argue, are not valid for our Paris Agreement. What are the probabilities being assumed? And often these are hidden within the text. Are aerosols taken account of? Are feedbacks appropriately embedded? And where they're not, is there some discussion about those feedbacks? Most feedbacks make the situation worse. So I think there are a number of things that, as a user of budgets, we have to be aware of those. Now, my personal preference is based on, to use the budgets of Robin Lamble, who's been heavily involved in the IPCC and most of the major reports since. And I think he takes the most measured and up-to-date science approach, in my view. This is a paper that was published in Nature Climate Change. So I use his budgets, which are broadly based on the same scientific framing of as the IPCC. Now, if you take the 1.5 and the 2 degrees centigrade and update those to January 2025, that's the key part. Remember, a lot of analysis doesn't update it to today. And even now, we're 20 days into January. And I'll come back to that in a minute, because that is also important. The remaining global carbon budgets for 1.5, for 50-50 chance, are 170 billion tons. And there's a number of other papers that come out with that same answer, Piers Forster and so forth. For 2 degrees centigrade, it's a larger number, about 575. For those that aren't familiar with these numbers, that's 4 years of global emissions, 4 years of current global emissions for 1.5, and 14 years for 2 degrees centigrade of current emissions at about 42 billion tons of carbon dioxide a year. If you looked at a reduction rate, an exponential reduction rate, that's 19% at a global level every year, starting January the 1st of this year, or 7% for 2 degrees centigrade. I mean, these are just sort of mind-blowing percentage reductions. Remember, 7% is greater than the reduction we saw in the most intense period of COVID at a global level. So we've never achieved anything like that before. If we were to draw a straight line, you'd have to be zero emissions, that's zero fossil fuel use for 1.5 by the end of 2032, the end of 2052 for 2 degrees centigrade. Another way to look at this, every month for 1.5, we use up 2% of the budget. Every month. I mean, how long does it take to arrange this event now? 2 or 3 months, you think that's 4-6% of the budget just gone. Even for 2 degrees centigrade, we're using 0.6 of the budget every month. And of course, every month we fail, the percentage we use the following month is even greater. So that's the global picture. But of course, we signed up, and we repeatedly sign up to make our reductions in line with equity, again, in accordance with the Paris Agreement. And the Paris Agreement and the UNFCCC use this language I don't particularly warm to, but developing and developed country parties as the two divisions. And there's, it's a very coarse division, but it's probably better than just looking at it globally. And then you can look at, well, what does that mean for the EU? And you can look at what does that actually mean for Ireland. So if we think about Ireland's carbon budget, and the next set of table I'm going to put up is very provisional. So this is taking the global budgets from Lamble, updating them to January 2025, and then thinking of those in relation to Ireland. So for Ireland's budgets, for 2 degrees centigrade, you'd have something like 280 million tons of carbon dioxide left. For 50 chance of 1.5, then you're talking about 80 million tons. And just look at the years. That's about 7.5 years of current Irish emissions. I think Irish emissions are somewhere, if you include aviation and shipping, which we would always include, probably somewhere around about 38 million tons a year of CO2 alone from energy. That's 2 years, just over 2 years of current emissions for 1.5 and 7.5 or the other. If you look at the reduction rates, even for 2 degrees centigrade, if you embed any, this is quite a weak equity criteria in there at a global level, then you would still need over 12% per annum reductions from the start of this year. And it would be over 30%, slightly over 30% for 1.5. If you did 0 years, you'd be talking about zero emissions from Ireland from CO2 by 2028. And that's not much similar to, it's very similar to other wealthy countries, by 2039 for 2 degrees centigrade. So This is just hugely challenging. All I'm doing here is taking the budgets out the best papers that we have on this based on IPCC and simply applying some arithmetic and an element then of some degree of justice to compensate for to account for the common but differentiated responsibility commitment. I think for the 1.5, because I've been asked to talk about 1.5, I mean, I'm sure we all just sit here and think, well, that's simply impossible. You cannot deliver those sorts of rates, 30% per annum, and that within 3 years, Ireland has to be zero emissions from all fossil fuels. So if you just took it at an equal per capita level, so that's not fair, of course, just taking a global equal per capita level, you don't get much leeway, unfortunately. 110 million tons, sorry, that should say million tons, they're not gigatons, million tons for Ireland. That's about 3 years of current emissions. So that's about a 25% per annum reduction rate and zero emissions by about 2030. And I should just add, there's a paper that came out last Friday from the UK Met Office that comes across with similar numbers, not for Ireland, but the global level, that globally we need 20% per annum reduction rates now to stay with a 50-50 chance of 1.5. This is what comes out of being brutally honest about it, lying and delusion for 30 years. The climate has carried on warming, and we are where we are today because we have hoodwinked ourselves and everyone else around us about this, and the truth is coming back to bite. Now, all of this is taking a certain view on non-CO2 emissions, which for Ireland is massively important. The budgets we have from the IPCC do require rapid and deep cuts in global emissions of non-CO2 emissions. So those budgets, which are incredibly tight anyway, only hold if we do something about methane and nitrous oxide. In the Ireland's case, like it or not, that's a root and branch reform of agricultural practices, major cuts in production and consumption of meat and dairy. And of course, these things will happen anyway if we just sit back and carry on and let climate change impacts play out. The climate is indifferent to relative emissions. And I think that's another important point. It responds to absolute emissions. So there's no hiding in Ireland behind emissions per litre of milk or kilograms of beef. The climate doesn't give a damn about those sorts of intensities. It just says how many tons of these things you're dumping in the atmosphere. And it's the total that matters. And it's those totals that the Irish ministers, if they've got any integrity, need to be considering when they consider their policies. My headline conclusions for this is that for Ireland and globally, and I'm saying it's a very heavy heart, 50% chance of 1.5 requires cuts of 20 to 30% cut in CO2 from now. And it would also mean significant cuts in our non-CO2 emissions. I can't see how that is any longer possible, that pursuing 1.5 a 50-50 chance. I say that with a heavy heart because I'm fully aware that what we have actively done in the global north is we have decided to sacrifice the people, many people in the global south, their lives and their livelihoods, ripped apart their communities by climate change that we have locked in by our emissions, by our lies and delusion for the last 30 years. So it's with a very heavy heart that I say that I don't think 1.5 is in any way achievable. I hope to be wrong on that, but I can't say how you can do it. For well below 2, Ireland requires cuts of over 12% per year. And remember, globally, it requires 7% per year. And it also requires big shifts into agricultural practices. And I think also it's worth bearing in mind, if you add together the global pledges that have been made, the NDCs, then by the early 2030s, 2 degrees centigrade will be then where 1.5 is today. In other words, impossible. And so the time frame for delivery in major cuts in CO2, and remember the climate doesn't care about domestic legislation that's usually far too weak to deliver on our Paris commitments anyway. The time frame delivery is between now and 2030. Not what we do after 2030, but what do we do this afternoon? What do we do tomorrow? What legislation is brought in next week? No government ministers at the moment are taking this seriously. So I think on that final slightly depressing slide, thanks for listening.
Thank you very much, Kevin, for what is a very stark and a very real presentation. And I think what's clear is the commitments that we currently have in law, which are not even, frankly, being implemented, are not as ambitious as they need to be. On that note, and I'd like to remind all attendees, please, that if you have any questions, which we'll get to at the end of the webinar, can you please put them in the Q&A box? And I'm going to pass now over to our second speaker, Dr. Andrew Jackson, who is the Assistant Professor with UCD and an environmental and planning lawyer. Andrew has been involved in public interest environmental and planning litigation for many years, including before the Irish, English and EU courts. Andrew previously worked for the UK Government's Legal Service in the Department for Environment, Food and Rural Affairs and with NGOs Friends of the Irish Environment in Antashka, where he was Natural Environment Officer and in-house solicitor. Andrew's going to speak now about Ireland's legal obligations to remain within 1.5 degrees and some upcoming climate cases. Thank you, Andrew.
Thanks very much, Rose, and hopefully you can all see my slides and hear me okay. So I'm going to give you a bit of a whistle-stop tour, looking at one aspect of Ireland's climate law obligations, because in the time available, it's not possible, of course, to cover all of the interesting things that we could talk about. But I'm going to touch on a particular aspect of Ireland's climate law obligations and also mention briefly some of the upcoming climate cases, which are occurring against the backdrop of what I'm going to describe as a new legal reality for reasons that will become clear shortly. The starting point in any discussion here, of course, is the UN Framework Convention and the Paris Agreement. Important to recognise in the Irish context, because, of course, we are a so-called dualist legal jurisdiction. International law instruments such as these don't have direct effect in the national legal order. So the Constitution says no international agreement shall be part of the domestic law of the state, save as may be determined by the Oireachtas. So it's up to Parliament to decide what effect we give to these instruments in the domestic order, if any. Now, of course, when the original version of the Climate Act was adopted in 2015, the Framework Convention and the Paris Agreement were given weak legal effect. The obligations were kind of have regard to the objectives of these instruments. That was the form. But that all changed with amendments to the Act that were adopted in 2021. And I'm going to speak about that. Now, that's not to say that the Act is perfect, far from it. It has various failings and weaknesses. And if you want to delve into some of the detail there, I've footnoted an article that Orla Kelleher and I published a couple of years ago, which looks at the Act as amended in 2021 in some depth. But as Orla and I argued in that article, amongst the most impactful changes made in 2021 were the introduction of what I'm describing here as strong general obligations of consistency in the Act. That was a departure with the past. And so we argued that, these could be very impactful. And that, I think, is now only now beginning to be seen. These obligations have taken some time to work their way through the system, to be litigated and to actually come before the courts. And that's really what I'm going to focus on today. So the 4 climate cases that are pending before the High Court at the moment are going to test these obligations, amongst other things. And that is also going to be happening in light of the European Court of Human Rights recent judgment in the famous Klima Signorinen case. So what do I mean by these strong obligations of consistency? Well, Kevin touched on this already, of course. The central objectives of international climate law, UN Framework Convention, aims to prevent dangerous anthropogenic interference with the climate system. And the Paris Agreement gives some flesh to that, saying that the aim is to keep heating to well below 2 degrees and strive to limit heating to 1.5. And also that we aim to do that acting on the basis of equity and on the principle of common differentiated responsibilities and respective capabilities. Now, those central objectives have been given strong legal effect via general obligations of consistency in Ireland's Climate Act. I'm going to focus on 2 of those obligations of consistency, but as we'll see, there are several more, all of which could be very impactful in due course. So the first one I'm going to mention is in section 3.3 of the Act. It says the minister and the government must carry out their functions under the Act in a manner that's consistent with the ultimate objective of the UN Framework Convention and the steps specified in Articles 2 and 4 of the Paris Agreement, 2 and 4.1 of the Paris Agreement, and that includes the principles of equity and common but differentiated responsibilities. So what does that mean? Well, it means that in handling and adopting the various climate policy instruments under the Act, the Minister and the government have to act consistently with those central objectives. So in adopting a national long-term climate strategy, the Minister and the government had to act consistently with those objectives. There is an upcoming climate case challenging the long-term climate strategy, challenging the substance of that strategy, and that is expected to come before the High Court to be given a hearing date relatively soon. That's a Friends of the Irish Environment case. Also, in agreeing carbon budgets, the Minister and government have to act consistently with the objectives. Also, in agreeing sectoral emissions ceilings, so splitting those carbon budgets up between sectors, they have to act consistently. There is an ongoing challenge pending before the High Court relating to that process of dividing up the carbon budgets. And again, that's a Friends of the Irish Environment case. And again, it's expected to be given a hearing date before the High Court soon. Also, in adopting climate action plans, the Minister and government have to act consistently with those central objectives of international climate law. And here, there are two upcoming climate cases, and Rose mentioned these at the outset. There's a challenge to the 23 Climate Action Plan, which is due to be heard by the High Court next week. And then that's an FIE case in which CLM is acting. And then there is a more recently launched challenge that Rose mentioned, challenging the Climate Action Plan 2024, where CLM is the litigant alongside several individuals. Also, in adopting adaptation plans, Minister and government have to act consistently with the UN Framework Convention and the Paris Agreement. Now, what does that mean? The answer is we don't yet know for the purposes of Section 3.3, but we're beginning to get an idea of how the courts in Ireland are treating these consistent with obligations via a second general obligation of consistency in the Act, which you find in Section 15 of the Act. Now, this applies to so-called relevant bodies, and that is broadly defined to cover most public bodies in Ireland. So public bodies such as local authorities, such as on Board Pleanála, the Planning Appeals Board, shall, insofar as practicable, perform their functions in a manner consistent with the most recent Climate Action Plan, the most recent Climate Action Strategy, the Adaptation Framework, the furtherance of the National Climate Objective, and the objective of mitigating greenhouse gas emissions and adapting to the effects of climate change. There have been a couple of outings of this provision, one outside court and one in court, relatively recently. The first outing of this provision was in respect of the long-running saga of the proposed Galway bypass. Here, in the most recent legal challenge, An Bord Pleanála granted permission for the bypass in November 2021, unaware, they said, that 4 days earlier, the government had approved a new climate action plan under the Act. Friends of the Irish Environment challenged the permission by way of judicial review, and it didn't end up needing to go to court because An Bord Pleanála conceded the case, saying that they accepted that the failure to consider the climate action plan in accordance with Section 15, with that general obligation of consistency, made its decision unlawful. And so they conceded. So that was an impactful early outing of Section 15. Now, more recently, earlier this month, we had the Cool Glass wind farm judgment of the High Court. And if you haven't read this judgment, I'd encourage you to go away this afternoon and read it, because it's really one of the most extraordinary judicial decisions. There have been a lot of climate cases now, of course, a lot of climate judgments, but really some of the strongest judicial language about the climate emergency that you'll find in any case internationally. It's a challenge brought by a wind farm company, arguing that Bord Pleanála was wrong to refuse them permission for a wind farm. Bord Pleanála had refused on grounds of adverse visual impact in effect. And the wind farm company said that the strong obligation of consistency that applies to Bord Pleanála ought essentially to take precedence over such considerations. And the High Court, Mr. Justice Humphreys, who's in charge of the Environmental and Planning Court in Ireland, essentially agreed with that line of reasoning. The judgment starts from the basis of the Supreme Court's judgment in Climate Case Ireland and the European Court of Human Rights judgment in Climate Signorinum. It says, importantly, that Section 15, the general obligation of consistency on public bodies, has to be interpreted in light of the Climate Signorinum judgment. And it says very starkly, Section 15, it means what it says. You have to act consistently with these objectives. And I'm going to, there's a lot in this judgment, but just to touch on some of the important points. So the judge said, Ireland has a climate law framework, of course. This is in the context of Climate Signorinum, but it's clear it's not being complied with. The latter failure on the logic of the European Court of Human Rights judgment in Climate Signorinum involves a breach of Article 8 of the European Convention on Human Rights. I agree, said the judge, with the applicant that the approach of a general requirement of general application in Section 15 of the Act underlines, bear with me a second, and reflects the need for rapid, far-reaching and unprecedented changes to all aspects of society and the economy. He goes on to say the board, largely supported by the state, in other words, the Planning Appeals Board, largely supported by the state, recoils in horror from the logical implications of this and demands the right to continue business as usual. But an immediate end to business as usual is a precondition for planetary survival. Section 15 affects more than just how the board decides its cases. It affects how it trains its inspectors and board members in climate law and science, and how it internally allocates work so that only duly trained people who understand climate issues at a deep level should be allowed near projects to which those issues are relevant. And he finishes by, or at least with the part that I'm going to finish on, in case you're wondering, because Section 15, if I go back a second, appears to potentially have a bit of a carve out because it says public bodies have to, insofar as practicable, perform their functions in a manner consistent with these various things. The judge says it's not enough for a public body simply to assert that it's not practicable for it to take a decision in a particular direction. It has to be actually impracticable, in other words, objectively impracticable. So restricting the potential use of that carve-out. So that gives a sense then of how the High Court is approaching these general obligations of consistency. And I've looked at two of them, but there are many more in the Act. There is an obligation, for example, that the minister has to ensure that climate action plans and long-term strategies are consistent with carbon budget, with the carbon budget programme, the 15-year programme of budgets. That a minister of the government shall, insofar as practicable, perform his or her functions in a manner consistent with the most recent approved climate action plan and the most recent climate action strategy. That the Advisory Council has to act consistently with those central objectives of the UN Framework Convention and the Paris Agreement in proposing carbon budgets. And that's something that's relevant right at this moment because the Advisory Council has recently made proposals, as you'll know. And also an obligation that a minister of the government shall, insofar as practicable, perform his or her functions in a manner consistent with the carbon budget. So we've seen the approach that the High Court's taking to these consistent with obligations, and we've seen the approach they're taking to, so far at least, to the insofar as practicable carve-out. So to pull things together and finish up in terms of lessons, insofar as I can, I think these strong general duties of consistency in the Climate Act and alongside that the European Court of Human Rights judgment in Climate Signorinum present us with a new legal reality, and the implications of this new reality are only now beginning to become clear on the ground because cases are only now beginning to be heard and decided by the High Court in respect of these changes. It's also important to reflect, I think, on the importance of the pre-legislative scrutiny process that we have in Ireland and the utility of that, because the climate bill as proposed in 2020 to amend the original Act didn't in fact include these strong duties of consistency. And those strong duties were added as a result of the pre-legislative scrutiny process and the evidence that was given before the Oireachtas. So that's, I think, an endorsement of the importance of that process. I think our experience today also indicates the importance of climate litigation. It's not, of course, a silver bullet solution, but I think it plays and has played an important role. Consider, for example, the approach of the High Court in that cool glass judgment of earlier this month with the approach of the High Court in 2019 in Climate Case Ireland, where Friends of the Irish Environment lost at first instance and went on to win in the Supreme Court the following year. Part of the importance of that first wave of climate cases was simply in their laying out the facts of climate science and arguments pertaining to climate law and climate justice, such that many courts and many judges are now familiar with those arguments, and they're coming to their judgments now in light of that knowledge. And the point I'd like to finish up on is never to underestimate, I think, the importance of public support of such cases. And I'm conscious that CLM and Friends of the Irish Environment, as Rose mentioned, have a hearing in the High Court next week of the Climate Action Plan 2023 case, reflecting on the experience of litigating Climate Case Ireland between 2017 and 2020. It was incredibly powerful, the show of public support for that case, including hundreds of people turning out to watch the case in the High Court at first instance. And you know, if you can, if you're interested, I'd encourage you to attend one or more of the upcoming cases. And now, just before I hand over before I hand back to Rose and on to Oisín, hopefully this will dovetail well with what Oisín is going to say. But this new legal reality, as I say, is only now becoming clear, and it's certainly not clear to me that policymakers have adjusted to this new legal reality. This is a quote that appeared from Leo Varadkar in the Sunday Times this past Sunday, former Taoiseach, of course, saying, absent the Greens, the new government promises to do things that had been frustrated by their presence over the past 4 years, including new roads, lifting the passenger cap at Dublin Airport, ratifying CETA, energy security, including the possible introduction of a liquefied natural gas terminal if one is deemed necessary, the use of AI in policing, and strong support for commercial farming. Now, political promises such as these have to be seen in light of and understood in light of the new legal reality that I've described, I think. Thank you very much.
Thank you very much, Andrew. That was an impressive summary of where we're at. And I think just a quote worth reminding everybody of from the cool glass judgment so recently by Justice Humphreys, where he said that an immediate end to business as usual is a precondition to planetary survival. I'm going to pass the baton over now to our final speaker, Oisín Coughlan. Oisín is the Chief Executive of Friends of the Earth Ireland, the Irish member of the world's largest network of grassroots environmental organisations, with over 2 million supporters in 75 countries. As Friends of the Earth CEO, Oisín co-founded the Stop Climate Chaos Coalition and played a significant role in the campaign for a climate change law, which culminated in the passing of the Climate Action and Low Carbon Development Act in 2015. Oisín will speak now about what our scientific and legal obligations mean for Ireland's new government when the Taoiseach is eventually elected and cabinet appointed. Thank you, Oisín.
Thanks, Rose. It's great to be with you, and it's really fascinating to hear both Kevin and Andrew. Friends of the Earth campaigns for faster and fairer climate action, and climate action got a little bit faster possibly over the last few years. It hasn't got much fairer, and that remains our goal, that faster and fairer, in line with, well, to the best of our ability, in line with science, in line with the Paris Agreement, and at the very least in line with our our legal obligations, domestic and European. I think what all of this means, what we've heard from Kevin and Andrew, what it means for the new government is something that I've been saying to put it simply, climate change hasn't gone away, because the vibe, so to speak, around the election were, and since the election, was Fianna Fáil and Fine Gael throwing the Greens under the bus, and the voters also throwing them out of government at least, and almost out of Parliament entirely, and that in some way this signalled well, a desire is not too strong, but a move back to business as usual, to borrow the phrase that Rose mentioned and that Justice Humphreys mentioned, and to get on with things that somehow have been frustrated by actually by stuff that the Parliament as a whole enacted, and that supposedly the cross-party support for that law, with 7 of the 9 parties in Parliament voting for it, 129 votes to 20, taken on. But in practice, like, get the Greens out of the way and things might go back to normal. We won't have to think about this so much. Well, obviously, that's not the case. That's the government doesn't have to think about climate, or that it won't be under pressure to act in some way or another. And I think the first place to start for me, before I come on some of the more like legal and political obligations, is that one of the messages we've been hammering home to them is that the public, despite the way the media sometimes reports this, or the way that some parts of the Fine Gael and Fianna Fáil parties have talked about it, the public wants climate action. In fact, they want more climate action. One of the striking findings in the exit poll that accompanied the election, which was done by a number of organizations together, was that 51% of voters said that they thought that the outgoing government hadn't gone far enough on climate action, compared to only, I think it was 20% or less who said they'd gone too far. So, and I know people said, oh, that's motherhood and apple pie. People always say they want climate action in theory. But actually, I thought that wording was quite well written, quite strong written. It wasn't like, do you think it's important? It was, did the government go far enough? And it hadn't gone far enough. So I took some heart from that. And interestingly, 47% of Fianna Fáil voters and 44% of Fine Gael voters said the government hadn't gone far enough, compared to about 15% who said they'd gone too far. So for every one Fianna Fáil and Fine Gael voter who thought the government with the Greens had gone too far, 3 felt they hadn't gone far enough. And we have been hammering that message home as far as we can in our media and other engagements, to get the message across that, you know, just because you got rid of the Greens doesn't mean that your voters want climate action to stop, because in a sense it's the squeaky wheels inside Fianna Fáil and Fine Gael and outside, like Michael O'Leary launching Peter Burke's campaign, who are, you know, pushing to either delay, dilute, or derail climate action, in line with you know, vested interests who don't want to have to do the transition, who want to keep making the profit in the short and medium term before destruction, that are being heard and that are squeaking. But there is our point is that there's a silent plurality of Fianna Fáil and Fine Gael voters, and a silent majority of the public who actually want climate action. And of course, so we are sort of trying to, and I'll come back to talk about what I mean by this. The 2 risks I see have been sort of by the new government. So, like, as in the risks we face from the new government, one is opportunistic defeatism, and one is just destructive contradictions. And I'll come back to both of those. But in the first instance, of course, you know, the government faces the climate law, and it faces the European obligations, which aren't going to go away. And obviously, it faces, you know, the need to produce an action plan to vote on to decide on the carbon budgets before by the Climate Change Advisory Council for the 2030s. Now, to bring them to Parliament and for Parliament to vote on them, all of that is required under the law, just procedurally. But I think, just to come back to those things, I was most concerned by the opportunistic defeatism to begin with. This is what happened in 2011. With the connivance of the civil service, actually, the active participation of Robert Watt, who's now Secretary General of the Department of Health, who came out and said in the briefing paper that's written for the new incoming Secretary Generals of the government departments, that he hoped, and the new ministers, by Secretary Generals, that he hoped that the climate targets would no longer be decided on an ideological basis, as in the Greens wouldn't decide them, or never mind a scientific basis. And what Fine Gael did in that case, and with Labour's connivance, was effectively to spend 5 years saying those targets are mad that the Greens signed up for. We shouldn't have too difficult. We won't do them. And debating with the European Union whether or not we should have to meet our 2020 targets, rather than trying to. In fact, there wasn't. You know, people here have talked about bringing climate action plans to court. There was no climate action plan between 2007, which expired in 2012, and 2017, because Fine Gael, that government, didn't want to do one, because they didn't want to admit that they weren't going to meet 2020's targets, and they wanted to kind of say they shouldn't have to try to meet it, because we were too poor post the crash. There was a risk that this government would do the same thing as part of that vibe of the Greens are gone, that was all a bit mad, those targets. And we know there's those in the civil service, never mind those invested interests, who feel this. The targets are on the current targets, never mind the one that Kevin's talking about, are unreachable, and that we shouldn't be trying to, that we should be beginning to make our excuses as to why we won't. The good news, albeit of like limited good news, is that the programme for government, which has problems I'll come on to, recommits the government to the 2030 target of 51% reductions by 2018, which those nerds here know was an instruction to the Climate Advisory Council on the carbon budgets, but it is understood by the political system as what it's bound to try to do. And it committed to net zero. Interesting, that was the word they chose, net zero, climate neutrality and net zero by 2050. The Climate Change Advisory Council is introducing complications around that, what that might mean. But the government is saying it's committed to net zero by 2050 at the latest, and to having an annual action plan. Now, that's good news in one sense. They aren't going for opportunistic defeatism, but they are, in the other sense, simply reconfirming that they will abide by the law. All of those things are required by the law, but they could have been challenging it more directly. I think the risk we now face, and this is where the programme for government is at in our view, is sort of, we've heard of the term in Irish politics in particular of constructive ambiguity. It was the foundation stone of the Belfast Agreement on Good Friday 1998, that you don't quite fully say what you mean and you try to play both sides and you get everybody going along. But that can have a role at times. But what we're seeing in the programme for government is destructive contradiction. So they commit to the targets, and then they also say they want to have more roads and more data centres and more commercial agriculture. And how we described it in our press release, borrowing from some of the discourse around Brexit, Kevin, was that this is climate cakeism. Have your climate targets and have more pollution too. And this is where, I think we're better off. We're at a minor advantage as campaigners working in a situation of destructive contradiction than in opportunistic defeatism. Because if the government was just saying, this is madness, we're not going to try, it would be harder than whereas we can now say, well, you said you were going to try to do this, you were going to respect those targets, but your actions don't match it. So that's where we look like we are now, that we would be contrasting the things they try to do or want to do with what they've said on the targets, and the fact they haven't laid out actions that meet the targets, and in fact they're laying out actions that take us further away from the targets. What actually they should be doing, of course, and I won't go into much detail on this, but I think I saw Hannah Daly in the list of attendees. We rely a lot on the analysis that the UCC and Professor Daly and her colleagues have done around the big 5 things that the government could and should be doing to reduce our reliance on fossil fuels. So stuff around wind, energy, solar and the grid, electrifying transport, reducing car use, retrofitting and heat pumps, and decarbonising industry. Like that 90% of our existing targets can be met by what UCC have laid out. On agriculture, it's more challenging, but there's the land use review, there's the nature restoration law, there's LULUCF. There's basically admitting that our agricultural model of exporting intensive beef and dairy is not sustainable, and moving to a just transition to a new agricultural model. That there are some of the debates that we should be having over the next months and years. That's what should be happening. And we should be getting political leadership from this government. They'll have to decide this now. If they've adopted the targets, are they going to be speaking through both sides of their mouth? And how long do they get away with that? And of course, there's a role for civil society to come on to. But under the climate law, we campaigned for 14 years for both versions of the climate law in Friends of the Earth. It was our core campaign for 14 years. We initially were focusing less on the legal side and more on the role of the Climate Change Advisory Council. Like I shouldn't really say this out loud, but the worst case scenario under the climate law, we used to say many years ago, was that we could no longer fail to meet our targets in secret, as in it would be subject to transparency and accountability. Because in the old days, we'd set targets with the EU and then fail to meet them, and no one would notice. The media wasn't paying attention, Parliament wasn't paying attention. Now we have the Climate Change Advisory Council with its annual reviews. We have the EPA focus on our compliance with the targets. We have the obligation on the Climate Change Committee in the Dáil to hold ministers to account based on the EPA and the Climate Change Advisory Council reports. We have the media to some degree paying more attention to those annual moments in the policy cycle. So there are lots of opportunities to try to hold them to account, and there needs to be a lot of civil society activism and campaigning too. And of course, we have the legal side, which wasn't I was always more focused on parliamentary accountability and public accountability, but obviously legal accountability is built into laws, and we are beginning to see that have an impact, as Andrew's laid out. So I really do think over the next 5 years, while organizations like Friends of the Earth will primarily probably still focus on the procedural accountability and parliamentary accountability and on mobilising public engagement and accountability, we absolutely see an increasing role for legal accountability if the government is failing in its duties. So I think we do have a lot of levers to hand as civil society, but we also have our work cut out for us. And we may have avoided the worst case scenario of the government reneging on its commitments and under the law, which is still nowhere near where we need to be under Paris or under science. They haven't done that, but they're obviously not actively setting out in a proper way to meet them with an imperative to act and to lead. But we have the tools to try to counteract that in various ways over the coming years, and I look forward to working with people to do that in times to come.
Thank you very much, Oisín. That's a very powerful call to action to everybody on the call. I'm going to jump straight into the Q&A because I'm conscious we have 8 minutes and we have lots of very complicated questions to cover in that time. What I'll say to the panelists is to try and keep the answers as brief as possible given the time that we have. Just an observation as I'm going through the comments here from Barry McMullen to you, Kevin, just pursuing 1.5 degrees may no longer be possible, but even if or when it's exceeded, we still have an obligation to do our best, I suppose, and not just do our best, sorry, but to do all we can do to unstabilizing and keeping within 1.5 degrees. Skipping down, there's a question for you, Andrew, about the transposition of the Paris Agreement into domestic law, where Barry indicates that he has heard that some public officials are only actively briefing that Ireland's only obligation under Paris is via the EU. That is, if we discharge our EU obligations, we ipso facto meet Paris Agreement obligations. Is there a legal basis to this?
No, I don't think there is a legal basis to that argument. And to try to cover it briefly, in the first wave of climate cases, Urgenda in the Netherlands, Climate Case Ireland, and so on, the EU level and EU law was entirely cut out of those proceedings and kind of irrelevant to those proceedings, which the proceedings went from UNFCCC, Paris Agreement, to domestic law and European Convention on Human Rights obligations, precisely because the argument then was, well, in any event, the EU and EU law is not doing enough to address the climate emergency, and therefore saying we're complying with our collective EU goals, even if that were true, is not a good defence to an allegation that you are infringing rights under the European Convention on Human Rights, for example. So no, for the same reason, I think simply saying if a country was in the position of complying with all of its EU climate law obligations, that still would not necessarily be a good defence to an argument that you're infringing my rights under Article 8 of the European Convention on Human Rights, pointing to Clima Signorinum.
Thanks. Thank you very much, Andrew. For yourself, Kevin, from Paul Price, in its recent December 2024 National Carbon Budget recommendation, Ireland's Independent Climate Change Advisory Council recommended reaching temperature neutrality by 2050, test of alternative emission scenarios. Do you think this is an adequate test given global 1.5 degrees overshoot and developed nation responsibility?
I'd have to know a bit more details what they mean by temperature neutrality, but that sounds like another sort of weasel word way to get out of the obligations that we've got, which are to hold at 1.5, not to overshoot these temperatures. The language of overshoot is the new scam that's occurring in the interface between science and policy. That we'll go over the temperatures and then we'll go back. And the we is important. We'll go over the temperatures, then our children will find ways of getting back to them. And so that sort of language is really dangerous. It also then leads on to geoengineering, solar radiation management, all of those other incredibly dangerous techniques that some people are proposing. So I'd be very, very cautious about that language of temperature neutrality by 2050. We should not be exceeding 1.5. And if we fail at that, then we should not be exceeding 1.6 or we'll not be exceeding 1.7. Yeah. Every degree matters.
Yeah. Thank you, Kevin. For Oisín and possibly for you too, Andrew, if and when the government declares that the current legally binding obligations are unrealistic or impracticable and move to simply amend, repeal relevant provisions of the 2021 Act, what then follows in law and for civil society campaigning? Oisín, to you first.
Yeah, I'll address that, and I saw a question that related, not unrelated, from Barry McMullen as well. Just on the temperature neutrality thing, I'm not an expert, but I have been across this a bit. I've briefed on it a bit. And it's interesting. It hasn't been picked up by the political system yet, but it seems to be a way. And I've now forgotten the precise definition of what they mean by that compared to climate neutrality or net zero. But it seems to be a way to try to give a better deal or a loophole to agriculture. And it'll definitely get an outing and a discussion over the next 6 months here, because the government has to make a decision on the carbon budget as put forward by the Climate Council, and it'll have to get debated in Parliament. So there will be more outings to that question. But interestingly, the political system currently keeps saying climate neutrality or net zero, and we should hold them to that. And that is what the law says, climate neutrality. But obviously you can have a debate about what that means. But we will try to hold them to net zero at the latest by 2050. But anyway, on the question that you put to me, Rose, well, I think it's good that they haven't signalled that's their intention, and I think I'm going to say they'll be loath to Irish politicians tend to not admit defeat, but simply go on to lose, if you know what I mean. As in, I think it's not that likely that they will try to amend the climate law. I think it's more likely that they'll just miss the carbon budgets and live with overshoot from one carbon budget to the next, and not worry about what happens in 2030 when they would be handing an impossible task on to whoever's in government for the third carbon budget. I think that's more likely, and it's also kind of harder to fight. If they went for they tried to change the law, I think that'd be so obvious and so upfront. It would be a very strong mobilizing moment, because it would require, I think it would require a full amendment to the Act. They can change they can try to change the carbon budgets, but I don't think they're going to do that. So I think if they actually tried to change the law, it would be very upfront, very obvious, and would be a very big mobilizing moment for counter campaigning. I think they're more likely going to try to slither along. On Barry's question about is it not just opportunistic defeatism to sort of let them away with saying 51% and not the carbon budgets. I think there's a bit of a conspiracy versus cock-up question here. I don't know to what degree, when the politicians meet to write down words for governments, they even think through this properly. 51% has been their shorthand for ages. We certainly shouldn't let them away with the carbon budgets at all. I'm glad they remembered the 51%. But the carbon budgets are the ones that are in law and the ones that the procedures are actually around. So in our everyday advocacy, campaigning, and indeed legal actions over the next 4 years, of course the carbon budgets will be front and center. I just think it's to some degree it's just a linguistic shorthand they use, which we need to keep a focus on all aspects that the law, both political and legal obligations, it puts on them.
Thanks, Oisin. And I think it's actually good for people on this call and participants here listening just to note that there is a difference between 51% and carbon budgets, even in their own language and their own campaigning on this point. I have a question from Mark Willers for you, Kevin. I'm sure you know Mark. He's asking, what, if any, reliance states could safely place on negative emissions technologies such as CCS, given the fact that it's not yet possible and may never be possible to use such technological solutions at scale? My concern is that any such reliance breaches the precautionary principle and places a disproportionate burden on our children and future generations. What are your thoughts?
Well, I would agree completely. Negative emissions and in fact, carbon dioxide removal, some of the so-called nature-based solutions have been a ruse and a scam that have been far too easily swallowed by the academic and expert community. There is not one IPCC scenario that isn't absolutely stuffed to the gunnels with some form of carbon dioxide removal, and most of them are negative emission technologies. These technologies do not exist at scale. They're just a few thousand tons they're capturing now. And even if they do work, they will be required to remove or to counter the non-CO2 emissions, residual emissions from agriculture. Even if the whole world goes vegan, which is pretty unlikely, but if it did, then we would still have a lot of nitrous oxide emissions and some methane emissions. And you have to stop the warming from those. So you cannot use negative emissions in any way to compensate for energy emissions, and you cannot use them either to counter for a very rich animal-based agricultural practices that you have in Ireland today. So negative emissions are part of the problem, not part of the solution.
Another question for you, Kevin, one that's close to my own heart, is around the non-inclusion of international aviation and shipping in carbon budgets 3 and 4. We know that that is what happens in most places around the world, with the exception of, as far as I'm aware, UK and New Zealand. But your thoughts on that, please?
Yes, if ICAO, which is the International Civil Aviation Authority, organization, if they had got their act together, then perhaps we wouldn't have had to. We could have left aviation to that body. They have fundamentally failed, and they've been an obstacle to driving any significant change. Therefore, it's incumbent on the nations to take that into account. I think it's slightly different in shipping, because the International Maritime Organization has done a much better job and is doing a much better job. Still very challenging, but it's doing a much better job than for aviation. And to be blunt about aviation, there are no technical options in the pipeline in the time frame that matters. So the only way to deal with aviation is to reduce demand. And that is a very, very uncomfortable message that those of us who regularly fly simply don't like. But there's no neat technical way out of this within a 1.5 or 2 degrees C time frame.
Thank you, Kevin. And final question, and my sincere apologies to other people who raised questions that we just didn't have time to get to today. But John Sweeney, and I'm going to direct it to you, Andrew, if that's all right. Is there a legal case for questioning the extent of compliance with their own obligations of semi-state organisations who fail to put Paris compliance front and centre in their interactions with stakeholders?
Yeah, sorry, I'm just reading the question here just to ensure I understand it. There's questions, of course. Front and center. I suppose, John, I need to consider it in the context of a specific semi-state in a specific situation to try to get a handle on it. But I mean, generally, I would say, well, look to, Oisin wants to come in, I think, too. Look to Section 15, look to the general obligations of consistency that apply in a very broad range of circumstances to public bodies, including, I mean, those relevant bodies are defined essentially by reference to the Freedom of Information Act, which captures some semi-state bodies, as you know. So yes, essentially, those Section 15 obligations should be affecting every aspect of the work of those organizations, including their interactions with stakeholders. But part of this might be about capacity building and ensuring that public bodies are aware of the full extent of their legal obligations under the Climate Act. And those obligations are only becoming clearer now in light of, as I described, High Court judgments and so on. So no doubt that will begin to filter down.
I think they're all a little bit clearer in the last 2 weeks than maybe they were before. Oisin,
Exactly.
did you want to come in?
Yeah, just briefly on that one. I think what you and Andrew just said about the building capacity in semi-states and the educational impact of the pool gas judgment can help, because we had a lot of back and forth with the last government on this, because we could see that semi-states, particularly the likes of GNI, Gas Networks Ireland, were not at all factoring in the climate law into their strategies. And we were pushing and doing research on the need to change the actual individual mandates of each of the public bodies, which we didn't get very far with. Whereas one of the not the pushbacks, but one of the sort of excuses for inaction on the part of the government was, like, they didn't have the political capital. Was one reality, not the Department of Environment at least, was that, well, look, Section 15 is there. To which our answer was, but you're saying to us that you as the state can't get your state agencies to do the right thing, and we should take them to court. That seems a rather inefficient way to do it. But that is where we are now. But I do think actually the recent Humphreys judgment might be a shot across the bows of all semi-states, and the threat of legal action now becomes more of a stick that we can wave around. And we may have to take more. We may have to all have to take some more cases for the likes of GNI to sit up and take notice. But I do think there's the interpretation that Humphreys has put on the law is really helpful.
Sure, and even just to be using Section 15 in our advocacy work, and using that language as much as possible. I'd like to just wrap up. Sorry, we've gone a little bit over and we didn't get to all questions, but it was an ambitious agenda to try and get through in an hour. I'd like to thank all of the participants for attending. We will make the recording available. I'd also like to really sincerely thank Professor Kevin Anderson, Oisin Coughlin, and Dr. Andrew Jackson for your contributions today. Thank you, everybody. Have a good day.
Thank you, everybody. Cheers. Bye.
Cheers. Bye.